Unpacking the misunderstood elements of the Expropriation Act and nil compensation. The recent discourse around the Expropriation Act in South Africa has ignited varied interpretations and sparked contentious debates, particularly regarding the concept of nil compensation. Critics like Martin van Staden argue that this legal device is tantamount to fraud, intentionally circumventing constitutional mandates. However, a deeper dive into legal precedents and theoretical underpinnings paints a different picture, suggesting Van Staden's view might be more ideologically driven than grounded in law. At its core, nil compensation is a legal fiction, akin to the corporate legal personality, which serves functional and pragmatic roles within the legal system. Just as the legal fiction of corporate personalities enables companies to operate as single entities, nil compensation facilitates specific state actions under particular conditions, deemed necessary and in public interest, especially pertinent to land reform. It creates a legal environment where property can be expropriated without direct compensation, with the compensation effectively being nil. This mechanism is vital for expedient land reforms, aiming to rectify historical injustices without financial exchange. Further, legal frameworks and past court decisions provide a backdrop supporting the constitutionality of the Expropriation Act. For instance, the case of Hafiji No and others v. eThekwini Metropolitan Municipality clarifies that compensation details need not always precede expropriation. This flexibility is crucial for state agility in public interest cases. Van Staden also references Hugo de Grotius, arguing that expropriation has always been tied to compensation. However, even Grotius acknowledged scenarios where compensation might be deferred or adjusted, especially under state necessities like war debts. Grotius's perspective underscores that while compensation is standard, exceptions based on context and greater public good are conceivable. Contrary to Van Staden's assertion, the Constitution itself, Section 25(8), allows for deviations in land, water, and related reforms aiming to redress past racial discriminations. Such provisions explicitly empower the state to undertake reforms even if they deviate from standard practices, including traditional compensation norms under Section 25(2)(b). The debate around nil compensation and the Expropriation Act reflects broader tensions between ideological beliefs and legal realities. While critics like Van Staden view the act as a manipulation of constitutional clauses, a holistic legal interpretation reveals it as a logical extension of constitutional powers and historical necessities. Lawmakers and legal experts argue that embracing such legal fictions, while controversial, is essential for progressing towards equitable land distribution and social justice. The discourse serves as a reminder of the complex interplay between law, reform, and public policy, where legal innovations sometimes challenge conventional interpretations to address broader societal issues. As South Africa continues grappling with its past and forging a path toward equitable land distribution, understanding and critically assessing these legal mechanisms becomes paramount. Thank you for choosing Satori News.